Okay, good evening. We're going to get this started. Tonight, I'm presenting this webinar primarily for the community, for the defence families. So there'll be some specific information, but also a lot of general information that's relevant for a whole lot of people, particularly young families, because we're talking tonight about having your wills done and making sure, most importantly, that you've chosen the right guardians for your children as part of that process. Quite a few people mistakenly believe that if you appoint godparents, that they have some kind of legal entitlement if something happens to you to look after your children, but that's not the case. So you do need to make that formal appointment in a will for it to be binding. So who am I and why is it important to, I suppose, listen to what I have to say? My name, as I said before, is Jackie Broman. I run TBA Law, have done for 10 years. I am a solicitor. I'm also a defence spouse of 20 years as well. And there's a couple of extra logos on the screen there that you can see, as well as being a lawyer, doing the degree to get to that position. I've gone on and done an extra master's degree, particularly in wills and estates, and then done a 12-month accreditation process with the Law Institute, particularly in that area. So I can call myself an accredited specialist in wills and estates. Just to give you a bit of an understanding of what that means, there's about 25,000 lawyers in Victoria. There's only about 80 of us that have that accreditation. And then I have won a couple of awards. One of the ones I'm most proud of is a Law Institute award from 2019, being the Regional Lawyer of the Year. So I've popped that one on there as well, so you know that there is some recognition out there for what we do as a business regionally. And over the last couple of years, particularly with lockdowns and things in Victoria, we've been able to move very much onto the online space and be able to serve pretty much anyone in Victoria and do a whole lot of estate planning as well for people around the country, primarily the 3 eastern states. So we can serve nationally as well. So what is estate planning like in 2022? It's very different from what it may have been even 20 years ago, let alone 50 or 70 years ago. In the 1950s, for example, your estate plan would have just looked like a will. Back then, I suppose property ownership was one of the foremost achievements that someone could reach. And then people may not have had much else, whereas these days it's far more complex. Tax laws have certainly come a long way since then. We now have compulsory superannuation. Superannuation is very highly regulated, as most of you would know, because it's not an asset that we can touch until a certain age. And there's a whole lot of regulation around how we can then take the super once we have access to it. We're obviously living a whole lot longer than people did 70 years ago as well. Many people sort of worked until 60, 65. And then probably didn't live much further into their 70s. So they might have been lucky to have maybe 10 years in retirement. But now we're, looking at least 20, if not potentially 40 years in retirement, and being able to fund that and all the things that come along with that as well. So decreasing mobility or decreasing mental faculties is where then we need to look at things like powers of attorney. Powers of attorney that cover not only being able to keep things running like your financial and legal affairs, but also medical decisions for you. So having healthcare directives as well in place can be very important as part of your your estate planning. And then in terms of the complexities of life, I suppose people have many more forms of investments, particularly trusts have become more and more popular. So whether someone might be investing in real estate into a trust or have self-managed super, which is a form of a trust, or run a business through a trust. So trusts also have to be taken into consideration with your estate planning, because a trust doesn't die with you, it continues on. So how do we make sure control goes to the people that you want it to? And similar, I suppose, as well with companies that you might establish and run a business through. And then there's also trusts that we can establish in a will as well. And, trusts that we might establish for children, for their education, or to protect our beneficiaries from themselves. And as I said, sort of early on in the piece, guardianship is really important, particularly for families who may not feel like they have many assets yet, but certainly if you have children who are under 18, the guardianship of your children is one of the most important things that you should be thinking about. One of the reasons I actually went into studying estate planning much deeper than I had in my early career was because I had a friend in the public prosecutor's office about 8 years ago. She told me about a case where she was prosecuting a woman and it was coming up to sentencing. This woman had run a red light, had no alcohol in her system or nothing, like it was just random accident, really. She killed this young couple who were crossing the street. This young couple had come down from New South Wales to watch the footy in Victoria, and they'd left their 2 young children at home, no wills. So these children and their families had had the opportunity to put forward some victim impact statements as part of the sentencing process. And it had been maybe 18 months. And these children had been in and out of the family court because their grandparents on each side of the family didn't get along. And so the grandparents were in a perpetual battle for the custody of these kids and also fighting over the money from their parents as to how they could be spent for the kids and who managed it. So I'm sure that's not what that family would have wanted, those parents would have wanted for their children. And I just thought, well, that could have been such a simple fix if we could just get out there and make sure that families know about this. And then, of course, I also see a lot at the other end of life as well, where people are just uncertain about how to deal with their elderly parents going into aged care, when there's a decline in ability to stay at home, a lot of fear around that, a lot of fear about having to manage someone else's money and then what the rest of the family might think about that, and so on and so forth, all the family dynamics that come into play. And doing your estate planning well isn't just about your assets. It's a huge legacy that you leave, and it takes into account all the family dynamics, sibling rivalries, power and control between people, and of course, when money's involved, that sort of comes more to play. So making sure that all of that's taken into account to make sure there's not a mess left. And so what happens when there is no will? Each state is slightly different, but generally they sort of follow this formula that it's called the law of intestacy. And if you pass away and you don't have a will, generally, if you have a spouse, everything will go to your spouse. So that might be fine for many people. And sometimes having no will is better than having a really poor will. However, if you have separated from a previous spouse and have a new spouse within a 6-year period, then those spouses have to work out between themselves how to split it. The law does not say how the percentages work, so that would be a horrendous fight. If your current spouse is not the parent of your children, your current spouse is entitled to the first $450,000 and has to split the rest with your children of your first marriage. If you have no spouse, everything just goes equally to your children. So again, that might be exactly what you want. If someone has no spouse and no children, so you might be thinking about someone in their early 20s, for example, everything goes equally to their parents. So that may be a reason why someone who is young actually needs to do a will, because if their parents are separated and they're estranged from one of their parents, they may not want it to go equally to their parents. Then sometimes we see these elderly people who are sort of the end of the line of their family. They've had no spouse, no children, their parents have passed. They may have had one brother or sister or not. They may have been an only child. So it would go to their surviving brother or sister, if there was one. If there wasn't, and their brother and sister had had a child, it would go to that nephew or niece. If there was no one, then it finally goes to the government. So some people also mistakenly believe that if they don't have a will, it goes to the government, but you can see that there is a whole list of people who would have a claim before the government did. Whereas when we make a will, we can actually appoint people into important roles into your will, and beneficiaries are not the only important roles, as in who your estate gets split between. So rather than just thinking about beneficiaries, some of the really important roles are executors. So they are the people who make sure that your wishes are carried out. Particularly if you, for example, know that you want to leave everything to your kids equally, but the dynamic between the kids is such that the kids can't work together to make that happen. So you need to find an independent executor to make sure that it happens. Or if you have young children, your executors also become your trustees. So your executors have to hold funds for your children until they get old enough. And so again, that's why it's really important to make sure that you choose the right people into the role as executor. If you are leaving funds for young children, you have to have at least 2 executors, because you don't want one having the complete control and power without the say of anyone else. And you can have up to 4. And yes, a beneficiary can also be an executor. That doesn't exclude someone from having that role. Then guardians. So appointing guardians in your will is really important. That's one of the major reasons for having a will when you have younger children or a younger family. You want to make that nice and clear who's going to look after your children if something happens to you. And in saying that, we make sure that there's not going to be any doubt about it. So, for example, don't appoint 2 guardians. Make sure you just have one who has all the decision making. So if you like a particular couple that you think might be your guardians, choose out of that couple who the primary guardian is going to be and name that person. And of course, then, yes, you can have backup guardians just in case that an original person can't do it for whatever reason, or something happens to them. So, for example, you might want your own parents to be one of your guardians, but you know that they're already in their mid-60s. So 10 years' time, when your kids are getting towards 18, that might not be what they want anymore. So potentially having a backup and then maybe a backup to the backup, you can do that for sure. The other thing I like to tell parents is that choosing a family member as a guardian is not your only pool of choice, so to speak. So I like to expand people's decision making and say, look, yes, your family may have like a blood obligation or a moral obligation to care for your children. However, if the only reason you're thinking that it should be your parents is because you don't want to burden someone else, just understand that it won't be a financial burden. And so if your friends actually have closer values to you than your own family, or they're more likely to keep your kids in the location that is more stable for them, or honour your decisions about how you want your kids educated and raised, then choosing friends would be a better choice in the long run. And to be honest, after you have that conversation with them, they're more likely to feel very honoured that you would consider them rather than feeling like it was a burden. So don't rule people out just because you think it would be too much of a burden. And then, of course, beneficiaries. So you do want to have a clear understanding about who you want your estate to go to and how you would divide that up. Which sort of then gets us to some of the important things to think about in terms of asset protection and trusts when setting up your will, and about how the superannuation will work as well. So in 3 weeks' time, I'm doing another webinar primarily around superannuation, because in fact, your will does not cover your superannuation. And so how do we make sure it also gets in the right place? There's also different tax treatments on superannuation. So there's some important considerations around how to deal with that, and whether we quarantine it or whether it's paid directly to certain people and not others, and so on and so forth. But asset protection, and we do this primarily through trusts, is an important thing to think about for your children as well. So it's about, okay, if other people are looking after your children's money, what they can use that for in the meantime, what instructions, how they invest it, what they can and can't sell, what can be paid for your kids in the meantime. Do we have a separate education trust to make sure all your kids are educated evenly? They're all given the same opportunities rather than it coming out of their own inheritance. So those things are important to consider. And then at what age would the trust end? So what age are you comfortable with your children actually getting their inheritance? They're legally an adult at 18, but quite often people are very uncomfortable thinking that their child might get $500,000 at 18 or more. And so thinking about, well, let's extend that age out to 25 potentially, which is my favourite or preferable age. But then what happens between the age of 18 and 25? We can build all those into the conditions of a minors trust. Or then we can also think about not actually ending the trust at all, but potentially when your child could take over control of the trust. So again, someone else might manage their inheritance until they get to 25, and then they can take over the management of their trust. But the inheritance is actually quarantined still in a trust, which gives it some protection from, for example, future spouses or bankruptcy or things like that as well. So things to be thinking about. Then some rules and myths that I like to sort of bust when I talk to people about their estate planning and wills. So the reason why we really try to make couples have mirror image wills is because when you're young, you're more likely to pass away in an accident than any other way. And so if you're in an accident together, how does that work? You wouldn't want wills that would be different from each other, principally because of this first little piece of the law, which says that if a couple dies together, the youngest person in that couple is deemed to have died. Sorry, I've said it the wrong way around, last. So the eldest has passed first because they're older. And so the youngest will is the one whose will stands. So if, and it quite often is the woman who's younger as a generalized rule in the relationship, and she hasn't provided for wishes that her husband has, then all of those things are irrelevant in his will. So mirror image wills are very important. The forfeiture rule is also another interesting one. It primarily gets a little bit of a giggle out of more elderly people who are starting to think that their kids are sort of pushing them towards the end of life, unfortunately, although they do say it tongue in cheek. The forfeiture rule is that someone who causes the death of someone else is automatically forfeited from being a beneficiary under their will. So whether it's criminally proved or not, yes, someone who contributes to the cause of a death can no longer inherit, and in fact, nor does their whole biological line. So it wouldn't even skip a generation and go to the grandchildren of a child, for example. The 30-day rule is also a rule to make sure you consider. It sort of works hand in hand with that first rule that the youngest is deemed to have died second. Because again, if you're in a car accident together, one dies on the scene and the other dies within 2 weeks, you're also deemed to have died at the same time, in that we don't have to go from one estate to another. It's just treated both have passed. Let's skip that first preference and we just go straight to the second. A gift over to children. So it's in fact, the law says that if you haven't provided for a gift over, it automatically goes down to the children of a beneficiary, so long as they are your own children. So for example, if you leave everything to your brother or sister, if they pass away, it doesn't automatically go to their children. But if you leave something to your children and they've passed away, if they've had children, it automatically goes down the line. So it might not be so relevant for your generation at the moment, but in thinking about generations above you, and if someone has passed away, it automatically goes down the line to children. But as I said, doesn't apply to anyone sort of outside the direct biological line. And then a couple of other ways of splitting up the estate and how to think about that. So the residue of an estate is basically the whole pool of the estate. So it's everything that hasn't been specifically gifted. So if you give your car to someone and your engagement ring to someone else, and then the contents of a bank account to someone else, everything else that you own then is part of the residue. And then it's a matter of, well, do I give dollar amounts or do I split it up into percentages or parts? And I do preferably let people know that you should do it in parts or percentages so that you don't accidentally miss something and have it fall into intestacy. So the rules that I was speaking about earlier about what happens when there is no will can sometimes even apply to part of an estate if the will doesn't fully cover someone's whole estate. So I have seen wills that, for example, leave the house to such and such, the bank account to such and such, you know, the car, whatever, to someone else, but then they've forgotten about this other investment that they had, or they've just left something out and they actually haven't had a residue clause, and then that falls into intestacy. So do think in terms of percentages. Then a specific or general gift is also an interesting way to think about things. I've already mentioned a couple of ways of thinking about a specific gift. So my car to my sister, my engagement ring to my daughter. So that is a specific thing, and it is to a specific person, so specific gift. However, you can also make a general gift in your will, which is an interesting thing that can compel an estate to actually buy something and provide it. So sometimes it's done for grandparents who want to leave something particular for their grandchildren. For example, rather than just leaving them cash, they might say, I leave 50 BHP shares to each of my grandchildren. So they haven't said my 50 BHP shares because they don't own any. So they leave 50 BHP shares to my grandchildren. It compels the estate to buy 50 BHP shares for each of the grandchildren. So that's a general gift. And then a specific or class of beneficiaries is also another interesting way to think about things. So a specific beneficiary is a named beneficiary. That's pretty straightforward. But a class of beneficiaries is, for example, my children or my grandchildren. So particularly for people who are getting a bit older and they're like, well, I want to leave $10,000 to each of my grandchildren, but their kids haven't finished having children yet. So we say $10,000 to each of my grandchildren living at the time that they pass away. And so they might have had 5 grandchildren when they made the will, but they have 11 when they pass away. So that's the class, is the 11, not the 5 when they made the will, but the 11 when they pass. If there is then another 2 grandchildren who are born after they've passed, too bad, the class closed at the date that they passed away. So that's how a specific or class of beneficiaries work. So just a few things, I suppose, to have an understanding of when you're thinking about doing a will, because there are a whole lot of elements to doing it and creative ways rather than just being really simple and straightforward. So as I sort of said early on in the piece, there's a whole lot of elements that are relevant to estate planning in 2022. All these things on this little poker chip image are what is included in a family legacy plan that we would do through my firm. So we don't just do wills, we actually look much more holistically. We can talk about and consider powers of attorney and what you might need there. Now, this can be really important for defence families, particularly if there's periods of time away from home, internationally deployed, or just serving overseas. Powers of attorney can be general as well, so they can apply for a specific period of time or for a specific asset, for example. So that can be very useful for those still at home. Medical authorities, so that someone has the authority to make medical decisions for you if you can't. That could be a temporary situation as well. So you could be in a coma, for example, having an operation, and something arises. If you don't have someone who can make decisions for you, and yes, your next of kin can to a degree, but they can't refuse medical treatment. Your next of kin can just sort of guide a decision about this or that, whereas a medical power of attorney can choose to refuse treatment. Advanced Healthcare Directive is a way of leaving instructions to someone about what medical care you may or may not want in certain situations. We also look at the superannuation. So as I said earlier, super is not automatically covered by your will. So how do we make sure it's directed to the people who need to get your super? And you do that generally through a binding nomination direct to your super fund. Now, again, for military families, there are 3 or 4 different styles of superannuation that exist at the moment, depending on when someone served and at what level you have the ability with the flexibility, I guess, around binding nominations, because there are some that are defined benefits and you don't have much choice with those, but having a better understanding of what choices you actually have and then doing the best that you can be very important. Testamentary trusts we've spoken about a little bit as well. So certainly a minors trust would be set up if you had children who are under 18, because funds have to be held until that child is no longer a minor. And then what are the conditions around that? So how can the funds be used for your children's education and upbringing while they're under 18? And the terms of that need to be set out. Whether you have additional life insurance or TPD insurance in case you have a permanent disability. These may not be so relevant directly for a defence member, but certainly for spouses, and what sort of TPD they have in their own superannuation and how that works. Instructions to guardians can be done separately from a will as well. So we do offer some really detailed templates so that you can leave fairly detailed instructions about the style of education that's important, the extracurricular activities that are important, how you want your kids raised around pocket money, medical care, all sorts of things. Family trusts. So if you already have a family trust for some form of investment, family trust doesn't die with you, so you have to make sure the power to run it transfers to the right people. Then your stuff. So yes, you can make a bit of a list in your will about who gets what bits and pieces. However, you may want that in a separate list so that you can change it more regularly than you need to change your will. Memorial instructions, if that's important to you. It's generally not binding, but that's the importance of choosing the right executor, because your executor has to make sure that your instructions are followed. And then, of course, the way you own property is all really relevant as to how or whatever comes into your estate in the first place. So jointly owned assets are not covered by your will. Jointly owned assets pass to the other owner. So again, thinking about defence members, if properties are being bought in one name and not joint names, or there's been assets accumulated before meeting each other, for example, then working out how to deal with those can be very important as part of the estate planning process. So we do all of this as part of our family legacy plan. It takes 2 appointments. So the first appointment is the information gathering. The second is the signing appointment. And in between, we prepare drafts. We run you through the drafts and we perfect those drafts via email. And all of this can be done via Zoom as well. Since COVID, we can now sign remotely and witness virtually. So there you go. I hope I wasn't speaking a million miles an hour, but I also wanted to share the link with you that's on the screen here. So TBA Law is the firm, but we do have a special page on our website for Australian Defence members. There's another 3 webinars after tonight on various topics that you can register for. And we do plan on doing more of those in years beyond 2022. So those will all be posted on that page. The recordings of these webinars will also be posted there. There is a specific 10% discount for our services, and that's advertised on that page. And there are ways of engaging us through there. So whether you want to email us, email me personally, or we do have a link where you can start the estate planning process for free online, where you can start filling in your information. You can save it. You don't need to submit it and make an appointment. You can just work through that for a little while before you're ready, and that's fine as well. So all of that's there on that page if you want to. And now otherwise, if anyone has any questions, I'm now going to stop the recording so that we can take specific questions. And if anyone who has watched the recording wants to ask questions later, my direct email address is jacqui@tbalaw.com.au. So that's JACQUI@tbalaw.com.au. All right, thank you.